Okay,
It's a little technical difficulty trying to get from one room to the next.
all right, great. We got you. So when you are ready,
All right. All right. Let's get started. Let's get started. Welcome to another segment of the Building Shatterproof Families, brought to you by the host ministry, Faith Tabernacle, St. James, Trinidad, where Pastor Anthony Henry is the senior pastor. We are so excited that you're here with us this evening because the topic that we are going to discuss is one that has relevance to each and every one of us. It's a topic that we've touched on a little bit of a little bit of each of the components of it this along the way over the last year, but now we're going to put it all together and discuss it as a whole because I think it's important for us to understand what it is to engage in estate planning. And that is our topic for today. So sit back, get your questions together, get your comments together, get ready because we have an esteemed panel with us today. A group of individuals who are experts in their field, who are ready and willing to share with you some very valuable gems that you can apply immediately to your life. So we would like you to participate. We have the emojis at the bottom with the different reactions. If you hear something that you really love, use the heart emoji, or you can use the thumbs up, you can use the clap, or you can, use any of those emojis to show us that you are engaging with the panelists. And of course, we would like you to use the chat because that's where you can post your questions or comments. And most definitely, feel free to raise your hand because we will call upon you to ask your questions verbally so we could connect with you. We can hear the passion with which you are asking the question, and you can hear what the panelists have in store to share with you today. I am your host today. I am Dr. Patricia Neff from Arizona in the United States. And we have with us three panelists. I will call them by name, and then I have each panelist to introduce themselves, tell a little bit about their background because we want you to know the level of expertise that we have here with you this evening. I'm going to start with Sister Marvelly Franklin with a Y. If you would unmute and give us a little bit about who you are and what you have to bring to us today.
Good night, everybody. Marvelly Franklin, that's the name with a Y. I'm born in Jamaica, lived in Barbados for over 30 years. I have a private practice. I'm an attorney at law in private practice for 24 years. I have a basic civil litigation and family law practice. I am an educator. That's my favorite job. Yes, I'm an educator. I have been a lecturer at the Barbados Community College for the past 19 years. And I do have training in postgraduate studies in arbitration and mediation, alternative dispute resolutions.
Thank you. So that's your
I'm
attorney
a
at law.
Christian, love the Lord, love to see his work go forward. Say that.
Amen. Amen. All right. All right. Brother Patrick Moore, tell us a little bit about yourself.
Hi, good night. I'm Patrick. I have worked in financial services from the time I left school many, many years ago. I started working in banking straight out from school. I was employed with um, Barclays Bank, CIBC, and CIBC First Caribbean from 1985 to 2011. During that time, I basically worked right through the bank from customer service to personal lending to small business lending to corporate lending. And then I did a stint of training as going around the different islands in Barbados and training persons on the systems that we were rolling out. And I finished my banking career doing what we call corporate credit risk analysis. Since then, I'm working as an insurance and financial advisor, with a very large company here in Barbados. I've been there with them now for the past 8 years. And during that time, I achieved my professional designation as a financial services certified professional. So basically, I've been spent all of my working life talking to persons about their finances. And like Sister Marvelly, I consider myself an educator because I see my role as to try and educate my clients in the best way for them to use their financial resources to achieve their goals. Um, I'm also a, I'm also a Christian. I'm also a lover of the Lord, and I try to make sure that in all aspects of my life, including my work, I apply His laws and His precepts and how I interact and treat to my clients. So that's me in a nutshell.
Thank you, Brother Moore. And last but by no means least, we have Brother Felix Pearson.
Hi, good evening. I'm Felix Pearson. I'm from Trinidad and Tobago. Professionally, I'm first an engineer, and then I went on to do business. So law is actually my third profession. I've been an attorney at law for the last 14 years, and my specialization is in corporate and commercial law. I do generally a lot of civil practice, and have been a freelance lecturer of business law at the University of the Southern Caribbean. Um, like my colleagues this evening, I too am a lover of the Lord, and I love teaching and educating, and I'm happy to be a part of the panel this evening.
Wonderful. Thank you so much. So you see, I did not lead you astray. We have an esteemed panel who are experts in their fields, and they are ready to go. But before this begin, I'm going to ask you in the audience to do me a favor. Get on your phone, use your text, go to your Instagram DMs, or however you communicate with your friends and family members and fellow church members, and ask them to come into this room, because the topic we are discussing tonight is of high importance to each and every one of us. So ping them in, get them here, let them come and hear what we have to offer so we can be a blessing to them as well. All right, so to get us started, we have a question, a very basic question that I'm going to ask Brother Patrick Moore to lead off with. And that question is, what is estate planning?
Okay, good. I thought I might have been muted. Well, estate planning, traditionally people look at estate planning from a very narrow point of view. Basically, it is basically process by which you plan for the distribution of your assets at death. But estate planning is actually much more than just that. Um, I'm trained to view estate planning as basically a process that includes the accumulation, the conservation, and then eventually the distribution of the assets that you acquire during your productive financial life. Okay, so it is not just somebody sitting down with you and planning on how, when you shut your eyes, who is to get the stuff that you would have accumulated. No, my job is to actually walk you throughout the whole of your life, setting up a plan, a strategic plan on how you're going to grow and accumulate wealth, how you're going to conserve it, meaning save it and still grow it safely. And then how, when you realize that as you get further along in life, you realize that, you know what, I can't take it with me. So you put a plan in place on who, when, and how these persons that you want to get your assets, how they're going to get it. So that's estate planning in a small nutshell.
All right, would anyone else like to chime in, or did that cover it adequately?
Very comprehensively.
Very comprehensive. Awesome. Well, here's this issue. So I have a 20-year-old and a 30-year-old, and they're saying, you know, I am too young to think about estate planning. That's for, that's for you old folks. Why should I even have to think about that now? I am young, I am healthy, I am enjoying my life. I'll wait until, when I'm maybe in my 50s, 60s and think about that. What would you say to that individual who is of the belief that estate planning is for older people? Brother Felix, could you lead us out on that question?
Sure. People generally have this concept that once you begin to talk about estate planning, and because the will is one of the main instruments involved in estate planning, people begin to see it as an end of life event. So, and they will think that because it is end of life, they still have a lot of time to get it done. But the reality is, very often when we ask what time it is later than we imagine. And young people do die too. So that, as Patrick said a while ago, estate planning begins with accumulation. And the instant you begin to accumulate your assets, that's the time that you need to begin your estate planning. So the morbidity that people will associate with it really is unfortunate, that people will think that once you begin to think about estate planning, you're thinking about death. That's not the case. It's really about you getting ready and planning so that it is not too late, so that you can organize to save your family the stress that they will encounter if it is that, God forbid, unfortunately, you exit this life without having some plan in place and someone have to make a determination about your assets.
All right. Okay, well, I have another one for you, Sister Marvelly. Maybe this one would resonate with someone. So, I have a little job. I make enough money to get by to pay my bills on a monthly basis. I don't have a ton of money in the bank. I am not rich. I am not wealthy. Why would I even think about estate planning? Isn't it true that estate planning is for wealthy people?
I think Patrick would have begin to address that in his earlier submission, in the sense that estate planning not only speaks to end stage, it covers where you are and where you intend to go. Yes. So at the end of the day, the man who begins early, has a better advantage of maintaining and sustaining and building, because there are some disciplines that you acquire as you as you progress in life. And as it relates, for example, to the end stage construct in terms of a will, we draft them, we're taught to draft them so that we say at law they're ambulatory. So if it is drafted properly, it will include after acquired property. So you may not have anything now, you think, you can still coin it in such a way that it will cover what you acquire as you go on.
So what I hear you saying, or you all saying, is that my estate planning is not about end of life. It's also about how I live my life.
And how you get
and
there.
how I manage my life right now.
Yes.
So that at the end there is something, right, for my loved one. So then I'm going to come back. I'm going to go ahead.
Yeah, if I may add as well, just to deal with this concept of wealth.
Yes.
And when we talk about estate planning is really not just about wealth, but it is about possession of assets.
Right.
So again, when people think that wealth, they would associate it with some abundance of assets, and that's not necessarily the case. Estate planning is for anybody who owns something. As insignificant as you may consider that something to be. And just to illustrate, it starts simply with employment. When you accept a new job and you go in and you sign those forms in the HR department, when you sign up for your group health, your group life, your pension plan, one of the lines that you're required to fill out on that form is whether you would name a beneficiary or you would direct it to your estate.
Right.
So at that point in time, you already should have a concept of how you want to manage that accumulation with time, whether you would wish to assign it to your estate or whether you will want it to go to a beneficiary. And sometimes we may feel that we do not have enough accumulated, and so we don't have to indicate or make a plan for it. By way of example, let me share with you a colleague of mine who is a missionary. He really doesn't own much. He survives on a month-to-month basis based on contributions and pledges from friends. But he was very interested in planning for his exit by way of having a will done. And for him, even though he was not rich in what we would call this world's goods in terms of finances and property and other major assets, the one significant asset he had that he was very interested in directing how it be given at his death was a 100-year-old Bible that came from 4 generations within his family. That was his most significant asset. And for him to plan in terms of determining how that will progress after he exits was through estate planning.
All right. So I have one more question before we go to the audience, and I'm going to leave it up to one of the attorneys to lead off. And that is, must an attorney be hired when planning one's estate?
Go, Martha.
Serious? Well, we have to put in a plug for the attorneys, but I think it is prudent, yeah, because you're planning your estate and there are certain pitfalls that you may want to avoid, right? You know your children, there are certain questions that the attorney would want to ask you to direct you what to do. Yes, and one of the things when you're planning your estate, and especially you have children, you know your children, yes, and you know who bad-minded and you know who is to look out for everybody else. Let us take it goes, yes, and you want to ensure that your estate is not dissipated by lawsuit and legal challenge, yes. So it is useful to have a lawyer in the process that can introduce certain things into that, into that estate to safeguard your assets so it goes where you want it to go. Yes, so you may have a church that you want to benefit. You don't want to let the pastor sign the will. Yes, because at the end of the day, he may be honest, but there's the whole notion of undue influence that can get it overturned, So you really need an attorney to guide you through the intricacies. Anybody can write a will, but the outcome and the probability of challenge, you're always going to be better off if you have an attorney helping you with that instrument.
And the gap there that the attorney really fills is the formalities that come along with the preparation of a will. There are some formalities that if they are not properly observed, the will, that can be fatal to the existence or the validity of the will. So those formalities are very important. So you benefit from the advice of an attorney with respect to those formalities.
Wonderful. Thank you. All right. I hope you're gathering all this information and writing it down because, hey, this is good stuff. So I'm going to go to the audience. Do we have any questions from the audience? I do see one from Pastor Griffith in the chat, but I'm going to hold off on that because that's going to come up in the segment that's coming up. So Pastor Griffith, if you could hold on for a minute, we will address that. Any other questions from our audience? You can unmute and ask if you can.
Hi, good night, Brother Reynolds here.
Hi, Brother Reynolds.
Yeah, I'm asking in connection in contesting a will. Let's say a parent would leave a will for a specific child where there are, other siblings. Let's say 3 or 4 other siblings. What is the possibility of having that will contested? Are there any grounds that it could be, and if not, or if so, why or how come?
All right, so we have a question about wills. So I guess we're going to have to go there. Since Pastor Griffith, I'm sorry, I'll come back to you. Let's address that question. Marvelly?
Oh God. All right. So let us get where it matters. First of all, I would say to people, your parents owes you nothing. Yes? The will is their final intention as to what they want to happen, when they are no longer here. So that if for whatever reason they decide to cut you out, they may have very good reasons and they may not have very good reasons. Yes? So we start from the premise that they owe you nothing. Yes? No. It does not mean that there may not be circumstances where, based on the relationship between the parties and the family arrangement, you may have, for example, a child who, well, not a child, one of the siblings who is home, who would have invested based on undertakings given by that parent that they may want to leave the property to you. So instead of going and buying your own house and invest with Patrick and to get some monies, you put your monies back into the family estate. Yes? In that kind of situation, the law allows you to challenge the will. That's an example. For example, on the basis of resulting trust, that you'd have relied on the promise, you'd have acted to your detriment, and you suffer harm. Yes? So in those kind of situations, the law allows you to challenge. But I mean, I've seen will challenge for other reasons where you just weren't satisfied with what you got. And that is again why I'm saying it is important to have the lawyers in it early, because you do that and then at the end of the day, the lawsuit is won or lost and the court says, well, let the cost be paid from the estate. In that case, the estate is being whittled down because of your challenge. Where if you had a lawyer, you could write in there, should anybody challenge the will, then the challenge must be borne from their share and interest. So if it's just greed motivating you, you're going to weigh the options. Am I going to go forward and lose what I have here as a certainty, or am I going to sensibly take what I get and be vexed with my father after I bury him?
Mm-hmm. All right, and I'm gonna go back to the question in the chat because it has to do with beneficiary. Since we are down that road, and I'm going to ask Brother Felix to address that. I'll read the question to you. What is the difference between naming a beneficiary and estate allocation?
If you're naming a beneficiary, and with respect to some entitlement outside of the will, you basically directing that at the point that benefit becomes payable, the person named as beneficiary is the person that is solely entitled to it. If you instead indicate for a benefit that you want that to go to your estate, then that item would now become one of the items in your will, at which time you will indicate how you would wish for it to be distributed, in what proportion and to whom. The benefit in that basically is that it allows you a greater measure of flexibility, because your will could be amended at any time and revoked at any time. So that as opposed to naming a beneficiary upfront and from being straddled with that, you have the flexibility of treating with it in your will. Now, there is an element of that Patrick could perhaps assist us with. I know in Trinidad, we have an issue with some financial institutions where when a beneficiary is named in certain financial transactions, you are not allowed at times to change that beneficiary. So you are bound because of the same thing that Matthew would have been alluding to before, because someone could name a beneficiary based on a profit, some promise and some investment of the person and a resulting trust of sorts that would exist in that arrangement. So the financial institutions will not allow you to change that beneficiary. So again, it is preferred, especially if you wish to have the flexibility, that you defer to estate as opposed to a named beneficiary, because you can end up with untenable circumstances. Sometimes you may have separations, whatever, and so on. You have your partner name as the beneficiary, and then you have to seek permission from that person to change that person as a beneficiary in order that your own wishes may be carried out. So it can be limiting if you name a beneficiary upfront. You maintain more flexibility when you defer to have that provision catered for in your will for distribution.
Okay, to address what Felix was mentioning, especially in the case of where you're naming beneficiaries on instruments like life insurance policies and so on, there are two classes of beneficiaries. There's revocable, which as the name would imply that you can revoke that benefit, you can revoke that at your pleasure whenever you feel like. And then there's irrevocable, which means that so let me give you a scenario. I have a life insurance policy. I name my wife as an irrevocable beneficiary. Once I sign off on that, I cannot decide because of whatever has happened, can go and change that unilaterally. In order for that beneficiary to be changed, she, as the irrevocable beneficiary, will have to sign off and agree to make the change on the beneficiary. Even though I am the owner of the policy, I can't make any changes on the policy, even though I might be paying the premiums myself and I am set as the owner. I cannot do anything with that policy without the irrevocable beneficiary agreeing and signing off on it. So if you can see, no matter how unlikely it may be, if you can see a scenario where you may want to change a beneficiary, then you should always, I always advise my clients, it could be your heartstring son, your one and only begotten son. It could be your spouse who you love to the maximum or whatever. I always advise you to put it as revocable, because the death of the irrevocable beneficiary does not release the legal ramifications. So even if you and the person are still good, but they just happen to predecease you,
Right.
that is a whole legal morass you have to go through in order to get that beneficiary change. So I advise persons to make the beneficiary designation revocable so that you can always change it without having that problem to go around. So if you have an irrevocable beneficiary, it is a lot of legal problems to get it changed, but to get around that, you just make it a revocable beneficiary, and that would make it a lot easier, make the situation a lot easier.
And Dr. Neff, if I may add, part of the challenge in transacting is that very often when people are asked to name a beneficiary, the distinction that Patrick just provided is not clarified to the person. So you don't have an appreciation that there is revocable and irrevocable. You just name a beneficiary only to find out downstream that it was actually an irrevocable. And if you had that appreciation before, then you would have had the benefit of making a decision whether you wish that assignment to be revocable as opposed to irrevocable.
Thank you. And you guys have answered the questions in the chat so far. Great information, because I was assuming that if the wife precedes the husband, that now you get to put somebody else in that place. I am glad to know that that's not the case. And I'm also glad to know that it's important for us to ask the question, is this revocable or an irrevocable allocation of beneficiary? So that's good information for us to know. So I'm going to go to the next segment.
Before we rush off to the next segment, I don't want to, I know, Madam Moderator.
Go ahead.
There are two follow-up questions. I think they came from section there where somebody is asking about people taking advantage and influencing the old people, and whether you can challenge the will on that basis. And yes, you can. I just want to clarify that. Yes, you can challenge the will on that basis, right? Where the person is not of sound mind, you're challenging the capacity to make the will. And where you think somebody is bothering their head and stressing them out, then that's undue influence. So the will can be challenged on that basis. And somebody's asking in terms of changing the beneficiary outside of a will. Remember that in the context of a will, you will not know as a beneficiary. Well, I'm not sure what Pearson does, but when I draft the will, you do not know what is in somebody's will until they're no longer here. Yes? Right. So at the end of the day, we're not going to change the will. You can't alter the person's testamentary intention after the person dies. The will becomes available to you once the person is no longer here. So especially on the old people, I don't even give them a copy to take home. I lodge the will in the repository of wills for living persons, and you get a copy of the receipt with a number. The death certificate of that person prompts the release of the document. That is when you're going to know whether you're a beneficiary or otherwise. Then the other issue they ask about in terms of if the beneficiary dies, who's next in charge? The beneficiary is not in charge of the will. The personal representative, the executor that is named in the will, is in charge of the will. Yes? The beneficiary basically has an interest in the asset that is left to you in the will. All right, so there's a distinction. You have situations where the personal representative may also be a beneficiary, but is functioning in two different capacities. So the person who's named in the will as executor is the person who's in charge of the will. So I think follow area, Dr.
Great questions. Keep them coming. Keep them coming. Thank you so much, Marveline. Let's move on to wealth accumulation. So, Brother Patrick, you had mentioned about accumulation being part of the whole estate planning process. So besides whatever I put in savings every month, what else is there to accumulate?
Oh, sorry. Repeat that question again because I was distracted by a question that popped up in the chat.
Yeah, me too.
We'll get back to it. Besides, when in thinking about accumulation,
Mhm,
besides what I put in my savings account every
mhm,
month,
mhm.
what else is there to accumulate?
Okay. Now, the process of estate planning, besides just in general helping you to grow an estate, and remember, estate is basically just property makes up an estate. So basically, what you're helping people is to grow their assets. The assets that you accumulate become an estate at death. But in the meantime, between now and then, you're just helping somebody, advising them how to grow their assets. So if I'm talking to a young person and they pose the question, you say, well, I'm 20, what do you want? I got the estate. Well, what do you want to know about estate planning? And they explain to them, but you want to have an estate. You want to get to the point where you actually have an estate. So my job is to help you meet that plan. So we sit down, I talk to them, I find out, what are their goals, their personal goals, their financial goals, all that sort of stuff. And then in doing that, I can help them draft a plan to achieve those goals. Now, one of the things that people don't realize is that one of the functions of estate planning is to provide financial security for you, for your family, and then by extension for yourself during your retirement years and all that sort of stuff. So a lot of people don't realize that when they hear estate planning, yes, wills, trust, and so on are vital, especially when it comes to the distribution stage. But in the accumulation and the conservation stage, there are certain things that help you build that strong foundation for the financial empire that you want to build. So besides the savings in your bank account is only part of the financial tools that you will use in your financial plan. That is short-term savings. Invariably, what you put in savings in your bank account, that's your emergency fund. Because when you're driving along and you hear poof, and you get a flat tire, where does the money come from to buy the new tire? Straight from your savings account. So my job now is to help you realize that, listen, you have your short-term financials, you have your short-term savings vehicle, your bank account, maybe some mutual funds, that sort of stuff. You have to start putting aside money towards your retirement years. God spare life, and you have a long life. So that's my job now. And that is all of those are part of your accumulation stage. Because anything that is an asset that shows up on the asset side of your balance sheet is your estate. So the money that you put aside towards your retirement plan, that accumulates over time, and that is part of your accumulation stage of your financial planning. Don't want to take up too much time.
So what if I'm interested in stocks and bonds? Does that count?
Of course, because anything stocks, bonds, once again go over on the asset side. So that is accumulation over time.
Mhm.
So you might say, well, I can spend a little $50 every month, and just buy shares at $50 every month. Next 10, 15, 20 years, when you look at your stocks and bonds, and if you were prudent and well, I know if prudent, fortunate, or whatever, and you invested in a company that does well, those were little seeds that you were sowing all the time, and the harvest comes over time. And that's when you will see that you have helped grow your estate, your potential, your future estate, by doing those sort of things. Now, my job as a financial planner is to advise persons on the areas that I have expertise in. So my job is to help people make sure that they have something in place that will replace their income if, God forbid, something happens to them when they're young. But then when I realized that, look, you need to have a will, then that's when I call Marvelly or I call Felix and say, listen, I
Okay,
have someone here that needs to speak to you because
I'm waiting.
what they need, what they need, what they need, you are legal, that is your profession. That is what, if I try to give them that sort of advice, you're gonna be the first person that can send the police to lock me up. So that is not my field of expertise. My job is to be your financial team quarterback. I'm supposed to tell you, okay, see that? I got a fella that you can talk to because that's tax planning. So you need a tax accountant. You need to drop a will or trust. You need to talk to an attorney, that sort of thing. So that's what my job is to know, have an overview of what the client, where he wants to go, what he will need to do to get there, and where to point him to get the specific legal professional advice that he needs.
So any kind of investment, whether it's land, houses, whatever, is part of that accumulation. All right,
Correct.
so I'm going to move on to Brother Felix, because, you know, I did not focus. I did not meet Brother Patrick until recently. So I did not spend my 20s and 30s accumulating as I should have. So now in my 50s, don't judge me. I mean, now in my 50s, is it too late to start accumulating? Has my time passed?
It's never too late. It may mean that you may have less opportunistic time to achieve what you may want to set out. But the later you start, it's just the more urgent it becomes. But it is never too late once there is the opportunity to do two things. One, increase your assets, and two, reduce your liability. I spoke a lot about building the asset base just now, but it's important as well as part of your planning that you plan to limit or minimize or remove entirely the liability that you face. For example, if you have people going into retirement, they never owned a property and they rent it for all their life and they're going in with a rent expense into retirement, that's a liability that can be detrimental to their asset base. If it is that you took a late mortgage and you're going into retirement and you have a large sum outstanding on that mortgage, again, that's a major liability. You want to plan your estate so that you minimize that kind of liability, so that the people who you leave behind you, you really don't leave them with an expense. In addition to not giving them a gift, you don't leave them with the liability of having to cover expenses that you would have been responsible for. And then, of course, you would want to be sure that you make adequate provision for any dependents that you have, minors and any other person who relies on you for their maintenance. So it's important in your planning as well, while you build your asset, you seek to minimize the liability that can accrue as well.
Okay. So there are two questions in the chat, and I'm going to hold on, don't answer it, because I think once we give information in this next set, let's see, where are we? We're on conservation. We're going to talk about wills and trusts. And I think we'll answer those questions once we address conservation. Excuse me. All right, so hold on, we're coming to you. So let's start with Sister Marvelly. What is the difference? What is there? Another chat. What is the difference between a will and a trust?
All right. So let me explain a trust at its basic level. The trust, basically, a trust is an obligation that the law puts on one person, who is the trustee, to deal with property for the benefit of others, the beneficiary. Yes. So you need not necessarily have a document. Yes. While a will, on the other hand, is a document that evidences the last or the final intention of the testator. So you can have, or the person who is dead, that's the testator. You may have a situation where you can have a trust deed that deals with property during your life, whatever. But most of the times, in my experience, elements of trusts are contained in the will. Yes. So it doesn't necessarily mean that they're on, a separate thing. So you may have a will, for example, and you may have a wasteful child or a child you need to mature a little before you vest him with what you think is his, right? What you then do is, in that will, you'll constitute your executor to be executor and trustee. Yes, and in that trust section, you will direct how the trustee manages the assets for that person. So you don't necessarily, he plans for it and he decides he's going to buy a big car as soon as he reaches 18, which is a wasting asset, and Patrick will be vexed. Yes, so you can say in the trust, he's going to get X amount on attaining 18, for example. He's going to get monies for educational advancement. He's going to get monies at 25. So all of that can be written into the will as an element of trust.
Mm-hmm. Okay. All right. So to go along with that, Brother Felix, what are the risks to my family if I do not have a will or a trust?
If you do not have a will or a trust, it means that there will come a point in time where you will not be around to direct how your assets are to be distributed, and it will be left up to those who survive you to determine how that will be done. We would wish, especially among Christians and good upbringing families, that there will be a level of agreement and decency around that. Unfortunately, that isn't always the case.
Right.
And very often it ends up in a lot of contention, which at the time that the family is grieving and really needs to be resolving those issues and settling financial matters, they may end up having to deal with a whole lot of emotional distress arising out of contentious family disputes. Then you would have, as Marvely would have engaged before, to settle the issue, you may then have to go engage an attorney. So then now you have costs being incurred out of the estate or out of individuals' pockets again to try to resolve issues that could have been predetermined if the person would have created some instrument to determine the outcome. And while all of that is happening as well, if you have dependents who were intended to benefit from your estate, you have those dependents not being vulnerable and suffering and being exposed from not being sufficiently catered for. And then sometimes if it is that issues remain unresolved, or if people are disinterested with an estate that was left with no particular provision, it could lie in waste and it can go to the state eventually if no one has an interest in pursuing it. So it's really a poor outcome for someone who would have invested time, energy, and effort in terms of creating some kind of estate for the benefit of those persons closest to them to have to really go through that kind of trauma to derive some benefit from it.
Yeah. And if I may just interject,
Yes.
The long and short is that if you don't make a will, your estate is going to be distributed by the laws of the land, and you may not like the way they go.
Okay, so let me go there, Marvely, since you mentioned that, because I hear a lot about probate.
Right.
I hear a lot about probate. While I'm planning or setting up my will and trust, should I also plan for probate? What is probate?
Right. Probate is the process of getting the court to sanction the will and to constitute your personal representative. So in the will, you would have named your executors, and the court needs to constitute them as the personal representative. So that's the process for probate. If you have not made a will, then there's another process where you go, letters of administration. It's still the probate department, where the court then gives somebody the power to administer the estate. Yes? So it's the legal process for both, whether you make a will or you didn't make a will. And there's some questions in the chat as they relate to that. I guess you're going to come to them.
Yes. Just one last question, and we'll handle all the ones in the chat.
Okay.
And it has to do with we are all Christians. We have a church home, and God has blessed us, and we desire to leave something for our church or for some other charities, maybe some NGOs. Should that also be included in the will?
It's a good place to put it. You include it in the will, and you make that as a part of a trust. Yes. So the trustee will administer that separately on the will. All right. So generally the executor is the trustee also. So when he administers the assets and vests the assets in whoever you left them to, then you don't want a vacuum. So you create a trust inside there so that he will then supervise in terms of whether you're going to set up a foundation, whether you're going to make money, sure monies go towards your church or whatever. Yes. So you can administer that to deal with your intention. So it's usually good to include that in the will.
Okay, so here's a question.
If I may add, Dr. Neff,
Yes.
just to add to what Marvely had said before, especially with respect to, I want to make a distinction with the trust and the will. And the point of the significant benefit of the trust as well is that the trust comes into effect the instant it is created. You could have a trust outside the will.
Right.
So whereas you could wait for a will and you would wait for the testator to be deceased, those provisions to take effect, you can make provisions for the distribution of your assets by way of a trust. Now, Marvely gave us the simplest form of trust, but there is also a provision for what you call a secret trust.
That's where I was going next. Go.
And that secret trust makes provisions for all kinds of things. In this Christian community setting, I'll give you a bad example. So for example, if a gentleman has an illegitimate child that needs to be cared for, and he doesn't wish his darling wife and family to know of that child, he can create a secret trust during his lifetime, where Felix is the trustee and he's charged with the responsibility of catering for the education and health and care of the child, whatever. He's not yet dead, but he has to make provision for this minor child, and he can do it by way of trust. It has nothing to do with him, but it has to do with providing for the benefit of someone that he wishes to bequeath his assets.
And let us, I would, so since you take one, so in the Christian community, let me mention the other one and the real life example. You have some of us, we are believers, and you have some family members who are not of all persuasion, or they don't view your faith in the same way you do. Yes, and you really don't want a situation to come up where they're fighting over whether the church that supported and nurtured you got what you want to leave for them. So what you do in the will or in the trust section, you give X amount to Patrick for the purpose that I have directed him.
Correct.
Patrick will get a separate instrument, so Patrick will know it belongs to the church, but they can't go and inquire behind that. So that's like a half secret trust. Yeah, you know, Patrick have some money, but nobody know what it is supposed to do, and the church get the benefit.
All right. Ooh, there are so many nuances to this trust.
Yeah,
I like it. I like it. Well, here's another question for you. Beneficiaries, excuse me. The question is, beneficiaries can independently agree to establish a trust, or can beneficiaries independently agree to establish a trust? Not on my money, right?
Remember, the beneficiary is benefiting from a gift.
Right.
They are not entitled, they do not have ownership of it. They can only do with what is gifted to them when they are in possession of that.
Right.
Until the will is fully probated, Marvin would have told you that the executor, the legal personal representative of the deceased person, is the person who has charge of the assets of the person. When the beneficiary gets whatever he gets, what he's entitled to, then he can do whatever he chooses to.
All right, I'm going to go back to the top where we left off before. Beneficiary who dies, won't their portion go to the estate, to their estate? So if I die, would my portion go to my estate of your assets and you're still alive?
It depends. You know, sometimes they say, are we not bluffing? They tell you, be careful to say yes or no at law. It depends. Yes? Because if he dies and he has no beneficiary, so he dies without spouse, he dies without heirs, then his portion will fall back into the pot to be divided among the other beneficiaries equally. Yes? So if he dies and he has a child, then his portion could go to the child. Yes? So it depends.
So if it's an irrevocable, if he's an irrevocable beneficiary.
Well, that's Patrick, an irrevocable beneficiary.
If it's irrevocable, then that does not go back to the pot. Would it go to the estate?
Unmute. Okay, right. Yeah, sorry. Didn't want to unmute. Revocable and irrevocable beneficiaries, I'm speaking strictly in the case of a life insurance policy.
Okay.
Right. So with a life insurance policy, if someone is an irrevocable beneficiary, what that means is that unless you manage to do whatever's illegal finaglings to get that person taken off, then what will happen is that whatever the death benefit that was supposed to go to that person is going to go to that person. And if they're no longer there, then it would the transfer of property that would go about would depend on if they had a will. If they had a will, then the will would say how his estate is going to be done. If there's no will, the die intestate, then as Marvelly said, the law of the land, which in this land is the Succession Act, will come into place. And from a non-legal perspective, describe it to my clients, is that when you have a will, is the equivalent of you going to your seamstress and she designs your dress just for you.
That's a
It
good
can only fit
analogy.
you. But when the law of the land has to do your dress, it's a one size fit all.
It's true.
And I know you ladies do not like one size fit all.
No.
So I usually use that as the analogy to let them know the best thing to do is to get a will in place. And as far as the insurance goes, name a beneficiary. Don't put it to estate, because that is a whole different can of worms.
So to go along with that, what happens if a person dies without making a will? Intestate. What if a person dies without making a will? What happens to their assets?
That's the process that I've already spoken before, called letters of administration. That basically, the law exists in Trinidad and Tobago. We have the Probate Act, we have the Estates Ordinance, and we have the Distribution of Estates Act of 2000, where the law basically steps in to identify who is in line in terms of a priority, a pecking order for applying, and then the benefit. So there is no option in terms of anybody determining how it is going to be done. The law prescribes. Once you have a surviving spouse, that person is entitled to 50% of the estate. And if you have what we call children, they are entitled to share the other 50%. Our law also provides benefit for cohabiting spouse or cohabitant who would have been a partner to the deceased for 5 years or more, entitled under law. If you have children that would have been adopted that are not blood issue, then they also enjoy that benefit as well. Just to connect a previous point though, with respect to a field gift. When we spoke earlier on, and we spoke about the benefit of having an attorney do the will, we had mentioned that there are certain formalities that go with it. And this is one of the technicalities that need to be provided for in the formalities of the will. Each will has a residuary clause. So for any gift that fails within the will, and predeceased, whether you can't find them, whether they decline, whatever it is, it then goes into what Patrick called the pot, and that is the residuary benefit distributed to the residuary beneficiaries, which are named in the will. So it must have that residuary clause that identifies who are the residuary beneficiaries. And any gifts that go into that pot will be distributed evenly to the residuary beneficiaries.
Okay, here's another question. If I have one child, have a property which I purchased on my own, then I marry a man who then comes to live with me. As a protective measure, would you advise I make a will portioning my estate to my child before the marriage?
Oh, let me just jump at it. First of all, a later marriage will cancel a will unless the will is made in contemplation of that marriage. Yes? So if you make a will to try to get your property out of the marriage situation and marry later, that will is revoked. A lot of people don't know that. It's important. Now, what I say to people, and I've had to do them for some of my ladies, I'll admit, if you have a gentleman and you acquire him, after you acquire your property and you have children, I'm seeing Patrick not looking too happy. What happened? You acquire him, after you acquire your property and you want to benefit your children, do a deed of gift. Now, the difference between a will and a deed of gift is that the deed of gift takes effect from the moment you do it. So it's a life disposition. I'm not use the legal word. It's a life disposition. Now, what if the children are ungrateful and you think they're going to put you in the district hospital or the arms house? You do a license to occupy until you die. So they can't put you out of your house. You can sue them on the license. Yes? Tie up the property for them. You can sue them on the license, and you make sure that when that gentleman comes in and begin to pull up the grass and clean the gutter, because that's all he's going to be contributing, he's not acquiring indirect interest in the property to be divided under the family law.
Oh, I love it. I love it.
Yeah.
I love it.
A question, Marvelly, you didn't have to do that for any of your male clients?
If what?
You didn't have to do that for any of your male clients? Oh, I just checking.
Yes.
Just checking.
Yes, I have deeds that I have children who own property and they don't know they own the property because we still keep the deeds. You don't give them.
Right, right.
You know, the men are happily married and the wives don't know that, you know, the asset you think he has, he doesn't have.
But just to add to what Marvely has said, and to save the will and to save the cost of having to redo a will, as she said, if you're doing the will before marriage, all you need to do is include the clause that said you are doing this in contemplation. So that it does not invalidate the will upon marriage. So just that clause will save the will without having to read.
But I'll still insist, Pearson, that the cleaner thing to do, I've seen it operating, is to do your deed of gift before. For the simple reason that that spouse, if he's not or she does not feel that they're adequately taken care of in the will, can still challenge that will under the Family Law Act. So it's two types of legislation in our jurisdiction will be fighting. So
similarly in our jurisdiction as well. And it's really just the options are available and the ease with which the person would want to avail themselves of whichever option they prefer.
Yeah. Just FYI to the audience, this video is going to be on YouTube. So if you have to go back.
Then I should have been on my best behavior.
No, this is good. I love it.
Too late now, Marvely. Too late.
So
don't have to hold back now. Just go. Keep going.
This is organic. I love it. So you can go back and listen and take notes. All right. There's another question in the chat. If two persons own a piece of land and one is deceased, does the children of the deceased have any entitlement to it? So that's assuming that the person has their own children.
If two persons own a piece of land, you have to make some assumptions here. The assumption is, how did the two persons own the piece of land? So that if the two persons own the piece of land as a joint tenant, as under joint tenancy, it therefore means that the survivor takes all. If the two persons own the land as tenants in common, the law says that they both have a distinguishable share. So I guess the children of the deceased then under tenancy in common would be entitled to the share of the deceased. But if they held it as joint tenancy, the one that survives will take the entirety.
So again, in terms of that clause,
you can get around it.
Right.
Yes, there are always things to do. Yes, you can sever joint tenancy during the duration of your life by serving notice on the other. And if you serve notice on the other tenant, then the law will treat it as a tenancy in common.
Okay.
But again, just for the benefit of the listeners, it is important to note, how do you provide for that? And that is another thing that is often overlooked at the time of the agreement between the parties for the joint, for the co-ownership. You need to distinguish, as Marvely said, between joint tenancy and tenants in common. And that has to be stated in the deed. And very often people inadvertently get into one arrangement or the other because that differentiation is not made at the time that the deed is being prepared. If you want the what we call the right of survivorship, where one person owns the whole when one departs, it has to be joint tenancy.
A joint tenancy.
If you want severance where you get your piece when you depart, then it has to be tenants in common. And that has to be stated explicitly in the deed.
All right, well, here's one from me. So a married couple divorces, God forbid. And the husband forgot to take the ex-wife's name off of the house or off of the life insurance policy as beneficiary. And he passes away. Can the current wife contest that beneficiary designation?
Did you say it was on a life insurance policy?
Either a life insurance policy or even the home.
All right, well, I will speak to the life insurance policy.
Okay.
A life insurance policy is a contract between the life insurance company and the owner of the policy. In this case, would be the deceased husband.
Mm-hmm.
It's basically a contract where the insurance company agrees that on the event of his death, this particular named beneficiary is going to be paid, which is why it's very important for owners of life insurance policies to make sure that they review their beneficiary designations annually. My job is to sit down with my clients at least once a year and we go over all those things, because this year things might be one way, next year they may be some way different. So we review and make sure that you just got married this year. Last year you had your mother on because you didn't have nobody, you didn't have chicken or child. Now you got your wife. You're sure you want to leave it as mommy, or you want to put the wife as the beneficiary? So unfortunately, in the scenario you just drew, oops means that the ex-wife is getting all the money. And I speak subject to correction from my learned attorney friends who know the law better than me. You could try to contest that, but they're not contesting that because it's a contract that between these two parties, and he did not change the terms of the contract, which provided it was not an irrevocable beneficiary. He had every opportunity to change it. Once you have a revocable beneficiary, it's as easy as you calling your advisor and saying, listen, bring that form, I want to change this because this body get me vexed. I don't want them as my beneficiary anymore. And you can do that every day for the next 5 years if you feel like. It's just simple as that. You can just change it by signing it, by doing the form. But if you don't do it and you close your eyes, don't open them back, unfortunately, it's going to go through the way as you had done, as you left it. So that's just how it is. That is in terms of a life insurance policy. When it comes now to deeds of title deeds on a property, like a family home or whatever, I will step back and take my place because my professional designation does not allow me to speak to that. So Marvelly or Felix, you can weigh in.
In our jurisdiction, the courts have a saying where they say the court will not attempt to rewrite the will of a willing testator. And that's why we spoke about the formalities. And so before, one of the formalities associated with the preparation of a will is that establishing that the person preparing the will has mental capacity, that they are competent to make that will. And after that, once that formality is satisfied, it is to be presumed reasonably after that, that what is written is a reflection of the testator's wishes. It doesn't mean that, that someone may not choose to challenge based on what other evidence they may want to produce in terms of relationships, whether it is you may have had other forms of settlement or whatever it is. But it will be arguable for them to go before the court with such an argument, and it will be an uphill task. But again, the court will determine on the basis of reasonableness based on the evidence that is presented to it. But the court begins on the premise that it will not rewrite the will of a willing testator, willing and competent testator.
Sure. And if I may just speak specifically to the other part of the question in terms of, because Patrick dealt with the life insurance, the real estate, divorce and that kind of thing. In my jurisdiction, you will not get a divorce until you have dealt with the property. Yeah, so you will not get the final section 42 in Barbados, a decree absolute, until all property matters are resolved between the parties. So it really wouldn't cause you a problem on the death of the person.
Good, very good. Somebody wrote in the chat, this is real pressure. Some people will not sleep tonight, for sure.
We thought we were making it easy.
Don't worry, Marvelly, business tomorrow.
Okay, I'm going to move on. I'll come back to, there's another question, but I'll come back to that.
Yeah.
We're going to talk about the distribution, and we've talked a lot about distribution already. So I think we've really covered the questions I have under distribution. We talk about beneficiaries. We talk about who's revocable, who's irrevocable. If you die and there's no will, who benefit. We've talked about all of that. So I'm going to move on. Let's see, there's a question. There's one. Now, there are some more efficient ways. Are there more efficient ways of distributing our assets other than by will? Lawyers will be paid in a prorated way on the total value of the estate, correct? Is that correct?
Pastor Griffith.
Yeah. You can tell, right?
First of all, I am not sure in terms of more efficient ways of distributing our asset. And when you say that, that may be one of the reasons why people don't like to make their wills, because they figure they're giving away their things and then they do not know how much time they have left after disposing of it. So the will basically takes effect when you die. It doesn't matter you make it 30 years ago, it is going, the assets are yours and you are free to use your assets and deal with your assets and sell them and do whatever you feel like doing with them, go on a cruise, whatever. You're free to deal with your assets until the day you die. Yes, so even if you have it in a will that somebody's going to get the watch or somebody is going to get the Rolex, you can pawn it. When you find a new girlfriend, you can do whatever you want to do with your asset. Yes, it takes effect at death. When they read that clause, they realize that you were thinking about them. So it is because it's an end stage disposition why it is so effective. Now you may have a situation where you do a deed of gift, for example, and it takes effect the moment you give it because it's an inter vivos disposition. Yes, so you give that to your ungrateful children and you go to the hospital for an operation and they refuse to receive you back into the house. But you have given it away, and it happened to Christians too. Yeah, you have given it away already. Yeah, so I really think in terms of disposing finally, it is still the effective way of doing it. And Pastor Griffith, I am glad however you take it, lawyers are going to eat. So if it is on there's a set fee for those yeah, right, you know, in some jurisdictions in terms of the cost, yes. And yes, you pay, lawyers are paid, I guess, in terms of the value of the estate for the administration of the same. But at the same time, it is not only about you wasting the money. You need to understand that the lawyer is also liable for messing up your will and messing up your property and messing up your conveyance and all of these things. So for the liability and for the years of study you pay. Just saying.
All right, we're going to move on to health. Estate planning also includes planning for your health. And what advice, and maybe this is one for the lawyers as well, what advice would you give the audience regarding advanced healthcare directives? You know, you've lived your life, you're at the stage where you're experiencing some health concerns. Some of them may be life-threatening. You know, what do you need to put in place so that your family knows your wishes regarding your health care and your end-of-life health wishes?
Yeah, and it's just as you stated, it really has to do with your relatives being aware of your wishes. This is all about the individual's wish. At that time, very often you may have situations where, for a host of different reasons, religious sometimes, financial, whatever it is, you may have families being unable to come to a consensus position with respect to the care of a loved one. And because that person may not be in a position to speak at the time, it is important that some indication be given. And especially if there's a concern with compliance with those wishes, it's always very good to formalize it by way of a deed or a trust indicating what those requirements are. So that it can save a lot of emotional distress as well, where families cannot come to a consensus position in terms of what needs to be done. If the wishes of the person is very well established, then it's a matter of respecting and honoring that person's last wishes.
If a family does not, if even after outlining your wishes in writing and you sign all the forms and so forth, your family does not comply with your wishes, is there any legal recourse?
It's really a moral obligation, more moral obligation than a legal obligation, because what that person will have really is an authority that says, I have entrusted Pastor Henry to make decisions. I am going into a healthcare situation where I'm facing a possible emergency or life existence threat, and I am delegating by way of deed that Pastor Henry is the person that will give instructions regarding my healthcare, whatever it is. if Pastor Henry chooses to disregard my own wishes to him, well, then he would only hear my voice from the grave, maybe. But it's really for him to honor my obligation and my reliance on him to carry out my wishes. It is really counterproductive when we get to that point where family members, and so when we become contentious, where people feel that they have to go to court to get an order to force compliance or to examine instructions. Those things are really not what you wish in those circumstances, certainly not what was intended. And we hope it would be a simple matter of compliance with the express wishes of the person who's affected.
Okay. All right. Let's go to the chat and see what's there. When a person dies, does his will become a public document? I.e., anyone can walk into the registry and see it after paying the necessary fees.
Not
in Trinidad,
yeah. I'm sure obtaining in Trinidad, but in Barbados, you have to complete a form. You have to state your relationship with the person, and when we seal the will, the executor is noted on the cover of the will. Yes, so after the will is opened by the executor, then you can get a copy. Yeah, it's not a public document. Anybody can walk in and get it.
Correct. And we have a similar procedure. It becomes easier once the will is probated. It is then on public record and can be accessed so that people would have information then on the contents of the will.
After,
After probate. Okay.
I'm trying to ask a question for you understand.
I have a question that was skipped, and I think it's for Brother Patrick.
Okay.
If you would like, if you would like to invest in stocks, what are the best options locally and internationally? Not sure if that's up your alley, but I'm guessing.
It's a question that my clients ask me from time to time. I am not a stockbroker. What I basically do is that it's what I usually do with all the circumstances. I usually try to impart information. So I explain to them exactly what stocks are. Basically, is you're buying an ownership in a company. Your gain or loss is basically tied to the fortunes of the business. So it's not something that you have a guarantee that if you spend $100,000 in stocks, that 10 years from now is going to be worth 100,000. It may be worth nothing. So I have to basically let them know that this is something that is a speculative type of thing. Is not quite gambling, but it's speculative. So I refrain from advising persons, oh, well, this stock is a good stock to buy or that stock is a good stock to buy. I basically try to empower them, give them the information that they need to so that they can make an empowered decision. I would explain to them the difference between buying stocks and bonds, buying mutual funds, which is a little more diversified of a risk, and then the other different things that they can use to try and accumulate wealth. Because stocks, as we said earlier, we mentioned it earlier, that buying stocks can be a way of trying to accumulate wealth or increase your assets over time, but it is not exactly the most safe way of doing it. So I don't try to advise persons. I will point them to a stock brokerage or a stock trader, and but I would try, if they're my client, I would basically advise them in terms of trying to teach them, make them more financially sophisticated so that they can make a good decision.
Okay. All right, we're going to open up the mics now. If anyone would like to verbally ask a question, feel free to do so.
Dr. Neff.
Yes,
Good
sir.
evening. If a person has a hereditary problem within their family, let's say cancer, and that person, brothers have passed, sisters have passed, can he will that when he comes down with the disease that he be euthanized?
Ooh. It's a legal question.
Yeah, you could will anything, but it doesn't mean the law is going to sanction it. Mercy killing is still illegal in our jurisdiction.
It's illegal.
It's illegal.
Okay.
Illegal. Okay. Yes. You could say anything. I remember a man left his wife the lowest coin in the realm, a Barbados silver dollar. The court didn't buy it. So you could will anything.
So I guess the answer is you can will it if you want, but the law will not condone it.
Oh, you wouldn't.
Okay.
So it's still against the law. Okay. Other questions? Seneca said, I really appreciate when Matthew 6:19 and 20 says, lay up your, your treasure in heaven, not on earth. Too many legal clauses.
Okay, and that is why Seneca pays us. So we put the clauses in our heads and draft you a document that you can understand.
Can you speak to the dangers of taking people into your home for lengthy periods and their rights to your properties? Ooh. So is the person stating that if you take someone into your home for a lengthy period of time, that they have rights to your property?
I think that is, to me, that is what they asked. I think there's something like that. If you, I heard it somewhere grapevine. I don't think I've ever read it, where if you have some taking, let's say, someone into your home and they're there for a number of years, they're not paying a rent, then they become a tenant at something or something. I'm not sure what the word is.
Tenant at will.
Tenant at will, yes.
No, but no, if they're not paying rent, they're licensees in my jurisdiction. So at the end of the, can you speak taking people into your home for lengthy periods and their rights to your property? I'm not sure what you have. If you are there as a licensee, the thing is, okay, can the person come back in and make some clarification?
Yes.
I think that, so the people into your home are those family members or those strangers that you have no relationship with. And how are they coming into your home? By permission, or are they paying, or whatever? So if you give us some clarification, I think that will enable Pearson to answer it better.
Okay, I can comment on the questions, my question. I once attended a seminar, a banking seminar, where it was told that we should be very careful about taking people into our homes. You know, like sometimes people are homeless and we decide that we take them in for a period of time, and then that short period of time go into many years.
Mm-hmm.
I thought that with time, those people actually can acquire rights to your property, because the court would say that, for example, they would have made some contribution over the years, so that now they have some sort of entitlement. It's something kind of like squatters' rights that we have here in Barbados. And it was wondering whether you can speak to this question.
No. Well, for the purpose of Barbados, somebody, by the sheer incident of coming into your home and being there for a time, does not give somebody an entitlement to your property. Yes? If the person is in the home and is making contributions and improvement thereto, because you have hold out to the person that they're going to get a benefit from doing so, then the law can imply what is called a resulting trust. Yes, but again, the person would have to be proving that. So it is not the incident of coming into your home that caused that, but it's the incident of contribution that the person is making based on what you have told the person. Yes?
Yeah.
We don't have squatters' rights to somebody's house like that.
So then how does that differ to say squatters' rights, where if a person just goes on a piece of property for a long period of time?
Right. No, the squatter's rights, okay. First of all, when you're a squatter, you're not acknowledging anybody as having a superior title. So you're occupying adverse to the interests of the owner. When I invite you into my house, you're coming in because I gave you permission. So you already acknowledge that I have a superior title to you. You're a licensee to be there, yes? So when the person squats on your land, the person is not acknowledging you as a landlord. And because you sat on your rights and did nothing over the time period, the law will say, well, the person, possession is 9/10 of the law. So
correct.
The person is acquiring an interest because you know of the person's possession adverse to your interest and you're not doing anything about it. Yes? So that is totally different from somebody coming in that you invite into your house just to be in your house, acquiring an interest in your property. You don't work like that. Although, be careful to say, I know of situations where you may have a relationship, somebody may come in and then over time, they're more than a licensee. Yes? So there's a relationship there that the other family member may not know about. Maybe or she's not of your standing, so you have not publicized that. But he has proof that he was more to you than a mere licensee, then that is a different matter in terms of acquiring. But by sheer taking somebody into your house, they don't get interest in your property like that.
Yeah, and just the same principle apply, and the important principle really is that possession is 9/10 of the law, and there's an element of it that kicks in as well, where, for example, if we deal with the scenario where someone is in occupation at the time that the owner deceases, and the property is now in possession of this person, you will be severely challenged just by virtue of the person being in possession to get that person out. But as Marvel is saying, the real insurance against that kind of thing happening is in ensuring that that person doesn't accrue any rights to themselves and they're established as a licensee to the property, or that they're a tenant. Once that is not established and there's an opportunity for them to establish or to advocate any other relationship that would have accrued to rights, then that is where they would have an opportunity. But being in possession is a critical issue, especially in the context of estate management. And so, because at the time that that the person passes, you have to be careful about who is in occupation, because you may find yourself severely challenged in terms of getting them out, even if you may have other interests being expressed.
Wonderful, wonderful.
Because I've also heard too about people like people who have migrated and other family members have taken possession. Well, not I shouldn't say they're residing in the property or on the property, and they proceed to do things like pay land tax, and they can use land tax receipts to say that I've been paying the land tax property for this amount of period. So by that, they think that, you know, I have some sort of entitlement.
Yeah, but in our law, the incident of paying land taxes doesn't necessarily mean that you're going to acquire rights. Nobody asks to pay the taxes, they tell you thanks. What I'm saying though, no, because a lot of people think because you pay land taxes mean you have a right to the people's property, and you don't. One of the things I'm also saying though, and I'll caution, you know, we gone all outside of the will thing, but this is, I like the fact that you are driving the thing. One of the things you do if you're overseas and you want relatives to stay in your property for conservation, or because you think you have a responsibility towards them, let them pay what we call a peppercorn
rent.
Even $1 a year. Yes? And make sure you get a receipt for it. So as long as they acknowledge you as the owner, it is going to be quite difficult for them to come and challenge you for your property thereafter. $1 a year, or they go and pay rent places.
Wonderful, wonderful. Does that answer your question, Sister Henry? Yeah, okay. All right, so now I'm going to ask each of our panelists to take a couple of minutes and give their final thoughts or their final takeaways for the audience.
Thanks, Dr. Neff. Yes, my questions were answered.
Okay.
I'm sorry.
No problem. All right, let's start with Felix.
Right, so I will be very brief. I would say that having a will is a very important instrument in life. And I would say if you don't have one, then you need to get one, and you need to get it done quickly. Doing so basically assures you that that your heritage, your hard labor, would be bequeathed in a manner that you would endorse, and that you would save your family the grief and the pain and the agony and the expense of having to treat with those unresolved matters when you would have exited this life.
Thank you. Patrick?
As we started off by saying, I just want persons to drop the traditional point of view of seeing estate planning as being something that is an end of life process. It is something that will guide your financial planning decisions from the time you earn your first dollar until the day that you close your eyes for the final time. Because it is not only just about how you're going to assign your lifelong assets, it's also the way that the plan that you're going to use to build those assets, to conserve them, to make the best. And if that is your commitment, the most godly use of the blessings that God has blessed you with in this earthly realm. As was mentioned earlier, you can decide that, you know what? I've done all I've needed to do during my life for my children and for my progeny. I want to make sure that I lay up treasures in heaven by making sure I bequeath something to a worthy cause, something that will further the kingdom. So all that can be part of your estate planning as well too. So don't think about it as just writing the will is important, and you need to do that to make sure that who you want to leave your stuff to actually gets it. But in the interim, leading all up to that, estate planning is important, and you should consult professionals like Marvelie, like Felix, like myself, to make sure that you can navigate all the legal ins and outs that everybody has had a better realization from hearing Felix and Marvelie spell them out. So that's my take.
And I did save the best for last. Marvelie?
I was very glad to be here tonight, my bad behavior notwithstanding. But what I would say, to us, and picking up from something that Patrick says, is that, you know what, there is a real issue among Black people, no racial thing intended. Yes, in terms of wealth creation. And for young people who are on here, don't be too quick to run from your parents' homes. You're working, stay home, invest in a piece of land. Yes, invest in property. Do not go and put up any big house to impress anybody unless you have some apartments on it that it is earning an income for you. Yes, you're owing the bank $500,000 in mortgage, that's an asset to the bank. Yes, so stay home, help pay a bill, and begin to build something. And the earlier you start, the better it is for you. And then we wouldn't be here quarreling about what your parents leave you. God bless the man who has his own. I would also want to say to the people who don't want to give the children anything, I have to strike a balance, right? That Proverb 13:22 reminds us that a good man leaveth an inheritance for his children. So you're thinking about your children, and you're all the way down to your grandchildren. Yes. So, and we're saying to them, draw near to your family. It should not be that other people are coming in to get what you're supposed to get because you treat them bad. They're only coming at the last stage when you think they're going to die to see what they have left for you. Do right by them. And I'm saying to the older folks here, when the young people are doing right by you, you do right by them too. So don't decide you're going to leave the assets to the one over and away that you like, who only send you a postcard at Christmas once a year. But the one who's there picking up your medication and running behind you don't get anything. Do right.
Thank you. There are some comments in the chat. Very helpful presentation. Thanks to all the panelists. And then Dr. Sutherland did put in the chat that this program will be on the Real Talk Family Life YouTube channel afterwards, because I think it's important for us to go back and watch it again, take notes, and take action. Don't just take notes and put it on the shelf. Take action and get things in place so that you are protected, as well as your children and your children's children are protected. I'm going to ask Pastor Henry to come on and, as a host pastor, to have final words.
Dr. Neff, just before we go, I just want to share screen. I love this little video. I found this some time ago, and I just want to share it with the audience.
I told my kids the other day, I said, let me explain something to y'all. If something happened to me and mama, I want you all to understand, y'all gonna be around the casket crying because I'm not leaving you everything. I'm just not. I'm gonna spend 85% of my income on me and your mama. Right. Yeah. Right. I'm gonna leave about 5–10%. That's it. The rest of the money, me and your mama going somewhere. Dad, we can't go on vacation now. No, I want to be with your mother.
It is not what you leave to them that makes them great. It's what you leave in them. If you leave more to them than you leave in them, they will want to do everything you left to them.
Yeah.
But if you leave enough in them, you don't have to leave so much to them because they can go out there and make their own way in life.
Cool. I'm glad you said that. Because now they ain't getting nothing.
all right. That's all right.
Oh my goodness.
Okay, so there is more to the estate planning. Make sure you leave a legacy for them. Okay, we want to thank you very much. I want to thank the panelists, Brother Patrick, Brother Felix, and Sister Marvelly, host Dr. Neff, for sharing with us. We have to do this in another quarter again with the same panelists. If you agree, put in the chat, yes, 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 yes. Those who inquire, and let me say to those of friends on Facebook, because I noticed there's some folk who are listening to the they were listening to the program on WhatsApp rather. They were listening to it on the channel because we were broadcasting live on WhatsApp. So there were several people out there looking at the program while we were here on Zoom. So let me thank you for joining us. We will be back in 2 weeks' time. And the subject then is one that you have to tune in and bring your friends to listen to. The church's approach in dealing with the LGBTQI movement. So have we been doing it right? Have we done it right? Come join us in 2 weeks' time as we talk about the church and the LGBTQI movement. Okay, and we want to thank you very much. Dr. Sutherland, our other host, there's somewhere out there. Dr. Sutherland, could you just turn on your mic? If I can find it, if I can find your video, I would highlight you and just say good night before we go, and the Lord bless everyone.
Yes, she is.
Hi, good night. I'm sorry, I forgot to change my photo. I had a work meeting today. Good night, everybody. I really, really, really enjoyed this session tonight. It was so fluid. It just went everywhere that we need to discuss as Caribbean people. Sister Marvelly, you are something else. We just need to go, let's talk Sister Marvelly and the legal system. Brother Felix, thank you so much for contributing. Patrick, it's always a pleasure to hear you talking about financial preparation. I love your phrase from cradle to grave, and we really need to be sensible in these times about what we do with not just our spiritual giftings,